Good evening and welcome to The Big Picture. I'm Ishan Russell. Tonight on The Big Picture, we focus on the crucial decision of the Supreme Court about the National Judicial Appointments Commission. Now, the Apex Court struck down the Constitution's 99th Amendment, which allowed for the NJAC Act as unconstitutional and void, restoring the collegium system for appointment of judges to the higher judiciary. Now, this is being viewed by many as a huge jolt to the government, as has generated a lot of debate in various quarters about the roles of the judiciary and the legislature. And to help us understand this issue and how it moves on from here, we will be joined in just a bit by the former Solicitor General of India, Soli Sorabjee. Meanwhile, over here in the studio, we have Maneesh, Chhibber, Senior Editor, Legal Affairs at the Indian Express. Dr. C. Kumar is with us. He's the Vice Chancellor at OP Jindal University. We're expecting somebody from the BJP. Sambit Patra is supposed to join us. Meanwhile, Nasir, Hussain, spokesperson for the Congress party, is already over here with us in the studio. Manish, I'll start with you just to put it into perspective for our viewers. Explain to us the decision that has been taken today and how does this move from here?
You know, the Supreme Court has said that it is unconstitutional, the constitutional amendment as well as the new system that was brought in. And that it is not in consonance with the Supreme Court guidelines, and that that a new system they will continue from here on. On November 3, they are going to hear the matter again, not this matter, but how to make the collegium system, which is a system that is used to bring in new judges to the higher judiciary.
But this wasn't an expected decision. This is a rather harsh decision as far as reverting back to the collegium system is concerned. No, many hadn't expected this.
I don't know which side of the spectrum you were sitting on. Because if you spoke to legal experts and if you were talking to the right people, people who wanted supremacy of the judiciary, who wanted an independent judiciary, everybody wanted such a decision. But if you are talking to the BJP leaders or people from the government, then I'm sure they would have wanted a 4-1 judgment against the challenge to the NJAC Act. But I, for one, am having covered the Supreme Court and the High Court. Right. I am very glad that this kind of judgment has come in.
All right, but Dr. C. Kumar, as far as the need for the NJAC goes, now many had said that the collegiate system had its own flaws and therefore such an action was necessary. Perhaps the government should have, as many are saying, in fact, senior lawyer Salman Khurshid of the Congress party was also saying that there should have been perhaps more communication between the legislator and the judiciary. Such a situation could have been avoided.
Well, if you remember, the entire context of a new constitutional amendment and the establishment of the Judicial Appointments Commission came about because of the fact that there was widespread dissatisfaction and recognition that arbitrariness did prevail in the collegium system of appointment of judges. I don't think there is any doubt about the fact that a lot of people across the political spectrum, including independent people, lawyers, as well as many judges, in fact, there have been many judges of the Supreme Court, retired, who have made serious comments against the collegium system. So let us be very clear that there is a very good reason why a new system of appointment of judges ought to have been there. There was also a good recognition among the fact that a Judicial Appointments Commission would have been a good idea, like many other countries, including England and other places. Now, the problem comes when the establishment of the Judicial Appointments Commission, which was supposed to replace what was considered as an arbitrary process of appointment of judges, ended up infusing a fair amount of arbitrariness in its entire process. So in some ways...
You're talking about the appointment of 2 eminent personalities.
Veto power, I mean, number of things. The arbitrariness is deeply embedded into both. And then, of course, the whole political process of bringing in both the Prime Minister and the Law Minister into initially in the selection of the eminent members and then in the selection of the judges themselves. In a way, what we are trying to deal with here is the fact that what the Supreme Court is trying to do in this judgment is not about whether collegium is good or not. Right. It was trying to determine whether the NJAC and the Constitutional Amendment was valid or not under the constitutional scheme, and they quite rightly decided that it is indeed invalid and unconstitutional and violates the basic structure of the Constitution.
All right, Nasir Hussain, as far as the Congress party is concerned now, the statements that we've seen from Congress leaders, it's still a wait-and-watch scenario for them. But the fact is that this got a unanimous approval in both houses of parliament. 20 state legislatures also passed it. And a lot of political parties say that this is the will of the people. Is this what the Congress party is also saying?
The Congress party respects the judgment of the constitutional bench of the Supreme Court. Independence of judiciary is the key fundamental to our democracy. We are with that. And then, but also there were problems in the collegium system. It was shrouded in secrecy, over confidentiality. There were some problems, and I think because of which this entire debate was there, and this has come out. But this judgment implicitly reflects the lack of confidence in the present government, which has been demolishing institutions, autonomy of the various institutions in the country, and not safeguarding the rights of the citizens. I think that is an important factor why I think this has come up. But nevertheless, we would like to wait and watch, because the Supreme Court itself has recognized the fact that these problems are there, and I think they have also sought to hear this entire case in the first or second week of November. We have to wait and watch with what kind of suggestions the Supreme Court will come.
Maneesh, you wanted to comment?
You know, what I find very amusing is that Congress and the BJP, for that matter, both of them, you know, they have to bring in politics in everything, including, you know, what is now a very important matter which concerns every person, every citizen of this country. You know, if the Congress felt so strongly about this, Mr. Kapil Sibal, the then law minister, who had drafted a similar bill, he told me once in an interview after, you know, one of the houses had passed this bill, that he would go to court because it was a badly drafted bill. He never went. And even now, look at what the Congress is doing. They are not ready to take sides. All that they are saying, it is a bad reflection on the government. If you feel it reflects badly on the intentions of the government, why don't you come out and say openly you will oppose it if the government tries to do that again?
All right, but an interesting thing you raised over there about the way the bill was drafted. Now, is there a problem with that? And that next, when we talk about this issue in November, can that be discussed?
You know, there are two separate issues. Number one, was the bill drafted badly? I think yes, because it was a bill which was bad in law. That leaves no scope for improvement. Once something is bad in law, how can you improve upon that? But having said that, I think what the government should have done, they should have consulted the judiciary. They never did.
Right.
They should have, you know, broad-based it. They should have been open to suggestions. For example, the veto and other things. For example, the primacy of the judiciary, which was a very important issue. They were not ready to do any kind of give and take on that. They stuck to 6 members. They said, so what? We will have 6 members, and then even then the primacy of judiciary will be protected. Coming to your second questions, you know, you were talking about what whether the Supreme Court will now take it, how the Supreme Court will take it forward from here on. I think the Supreme Court has very, very wisely decided that, you know, there is, and they have admitted, which is saying a lot for this Supreme Court or any Supreme Court. They have said, yes, there is a problem with the collegium system, and we will go into that from starting November 3. And I think it is a chance for the government also to make amends.
They should come out. Middle ground can be achieved.
Of course.
All right, but Dr. C. Rajkumar, you were citing international examples. You said how the judicial appointments, for example, happen in England. Now, in that sense, how are we placed with our law? And as far as the collegium system is concerned, there were a couple of laws that I read up in my research, and it seemed that as far as appointment, there is a lot of opacity as far as the collegium system is concerned, isn't it?
So to begin with, I think it's very important for us to recognize that while comparative examples of different jurisdictions, particularly developed countries which have deeply embedded and established notions of rule of law, could be used as a framework for thinking about it, but we have our own set of issues and problems. Rule of law is not deeply embedded into political culture within our country. So in that context, we have a situation where 20 years we have had an appointment system in the form of a collegium system. We have had number of controversies surrounding it, a recognition that we need to do something different. And that is the point where we should have taken far greater precaution and a far more rigorous process of formulating an alternative, which is in the form of the NJAC.
Right.
I strongly believe that the consultation process, not just with the judges, but a wider consultation with many academics and civil society and lawyers. I don't believe the Bar Association were involved. I don't believe the Bar Council of India itself, which is the main body which represents the legal profession, has been involved. There is a lot of consultation that is needed, because one of the big challenges here is we are talking about what kind of a mechanism will need to be adopted for appointment of judges, because that is critical to the protection of the independence of judiciary. These two are so, in fact, that's what the judgment says. If you look at the judgment, it talks about the relationship between appointment of judges on the one hand and independence of judiciary on the other. And that was a very critical link, and that's why I wish the government had taken a far greater degree of consultative process, which would have helped us to draft a better legislation. Because I want to be very clear about the fact that there are very few people, if at all, in the country who are supporting the existing collegium system.
All right.
It became inevitable that this particular framework of NJAC will not pass the constitutional scrutiny, and that's why it had to be declared unconstitutional.
All right, but I want to come to a political question, because Nasir, Hussain, it really comes down to how much the legislature interferes in the judiciary, how much oversight does it have over the judiciary, and vice versa. So in that sense, the Congress party has to take a stand, and you're saying that as far as this decision is concerned, it's a wait-and-watch scenario. But in terms of what has been happening over the past 10, 20 years, in terms of the Congress party stand, it certainly seems that you and the BJP are together on this one.
See, one thing is very clear as far as Congress is concerned, that the independence of judiciary has to be protected, and it has to be protected fiercely.
Right.
That we are very, very clear on that. But at the same time, when it comes to improving the institution or the institutional mechanism that is there, for that all the political parties within consensus within the country will have to work upon a system where we can bring in more improvement. Maybe we can take examples. Maybe we can take clue from the developed countries, as Professor said now.
Okay.
We can do. We should work on that. But at the same time, we should also see that when these kinds of deadlocks are there, we shouldn't allow elements within the government or outside the government to have to venture in some sort of an confrontation between judiciary and legislature.
All right, there's no one-upmanship between the judiciary and the legislature. That is what all government representatives have had to say today. Sambit Patra joins us, a spokesperson, national spokesperson of the BJP. And we're also joined by former Solicitor General of India, Soli Sorabjee. I'll give Soli sir the first go as this. Soli sir, as far as this judgment is concerned, it is indeed a landmark judgment. And what do you make of it? Mr. Sorabjee, can you hear us? We'll try to establish that audio link with Soli Sorabjee once again. But Sambit Patra is over here with us from the BJP. And Sambit, today many are saying this is a jolt to the government. The Congress over here is saying that this shows the lack of confidence of the apex court in the present government. What would you have to say to that?
No, in fact, this issue should not be politicized. I mean, as far as the presentation of NJAC is concerned, it was 100% support by all the parliamentarians, both the Lok Sabha as well as the Rajya Sabha supported it after due deliberation. And in fact, it's not that only the Bharatiya Janata Party was up for this. In fact, the Congress also wanted to bring in this, and there were due deliberations since long. I mean, as far as the Venkat Chalaya committee in the 2000 was concerned, as far as the Administrative Reforms Committee is concerned, as far as the Parliamentary Standing Committee is concerned, all were of the view that the judicial appointment that really needs some kind of reform. It is a reform issue. So in fact, the judiciary also today, when they were giving the verdict, they agree with the fact that there are certain flaws with the collegium system, and that would be looked on November 3rd. So I believe that if there was a flaw, that's what the government was trying to do. The government was not trying to infringe on the independence of judiciary. Rather, one of the cornerstones on which NJAC was formed reformed was to maintain the independence of judiciary and to see as to how the separation of powers between the various wings of the power corridor be maintained. So I see today, though I would say that the government would take a structured stand on it in due course of time. But the second question, which I believe if you have legal luminaries in the debate would be able to answer, is it possible? Well, yes, it is within the right of the Supreme Court to squash a proposition, but is it possible for Supreme Court to re-legislate something which was buried? And over here, that's a collegium system. It was a buried in a dead letter, as said by the government on the floor of the court. And today they say that it relives. It is a system which would be used. So is it possible? I would like to know from the legal luminaries.
All right, and we have Soli Sorabjee over here with us. He'll be joining us in just a bit, and we'll put that question to him. But Sambit, very quickly to you, another question, because we've had this little conversation for about 10 minutes before you joined in, and that was about whether there was a broader consensus that the government had to build about the NJAC, and that is where perhaps the government erred.
It was after broader consensus that the whole thing was presented in the parliament, and that's the reason as to why there was 100% support across the line. And as I told you, this consensus has not been only built in the political circles. Various other committees, Venkatachalaya committee, the administrative reform committee and the parliamentary standing committee have deliberated upon it. I mean, the only issue which many of the legal luminaries are also putting is, if two wings were to judge each other, how is it that one of them judges the relation between the two? Today, if it was to dictate the supremacy of whether the political supremacy exists, the executive supremacy exists, or the supreme judiciary supremacy exists, it is the Supreme Court which is deciding about the supremacy. Right. That is what is the problem over here. I believe it's a very mature system. It is not it's not a kind of battle between the two wings. In this mature system, it is a churning point where how best judges can be appointed to the country is a matter of discussion. So I believe it will take some time before we reach to a conclusion.
All right, and we have with us former Solicitor General of India, Soli Sorabjee, finally, and we can get through to him. Thank you very much for talking to us, Mr. Sorabjee. But very quickly, your views as far as this judgment is concerned, and how do you see this playing out in the future? Do you see the need, especially for how can we change the collegiate system around now that is going to happen?
Well, first of all, I have not read the judgment in detail. But what I find surprising is this, that it is accepted that the collegium system has failed. If they wanted to bring now this act does not in any way exclude the judicial voice in the appointment of judges. It doesn't. It was exclusive under the collegium system. So now the NJAC Act is not exclusive, there are other voices also. So I don't see how that affects the independence of the judiciary. If the court had any problem with the eminent persons and the suspicion that eminent persons can be those who may not be judges and who may really dilute the voice of the judiciary, then that provision could have been looked into. You could have read into that provision in certain conditions, or if it came to have struck down that particular provision. But to declare the whole act void, I think I was a little surprised. And besides, in which country does the judiciary have the exclusive voice in appointing judges and transferring judges? Surely, I'm not saying don't diminish the voice of the judiciary. It must still have an important voice. It must have, if necessary, a decisive voice. But it can't have an exclusive voice in the sense to exclude other voices, and one of them being of the executive, which is the largest litigant in the country.
All right, Maneesh, but I want to get you in on what Mr. Sorabjee is saying, and it's a rather pertinent point that how does one differentiate between the powers and who's accountable to whom? I mean, ultimately, we're in a democracy and accountability has to be maintained.
You know, Soli, I'm aware of his views, and rightly so, whatever he's saying, I totally agree with that. My only issue is that, you know, when you bring in politicians, they will destroy any institution. And the question of primacy of judiciary, that was something that had to be looked into. This court has looked into. But the bigger issue, and which is still, present, is that of that opacity of the current system, which is the collegium system. You know, nobody had a problem with judges selecting themselves or the lack of role of the executive. The problem was that this was a system where judges were selecting themselves. So that is why I said at the very beginning when Mr. Sorabjee was not there, that this judgment also leaves that door open from starting November 3. The court will start hearing, everybody, all stakeholders, anybody who wants to be heard, on how to make this system transparent. I think half the problem will be taken care of. Actually, the entire problem, if you were to make it so transparent that even anybody can stand up and challenge that. Right now, we don't know. Nobody knows who were the people considered. How was the selection process done? Who were the people? Why were some people left out? Why were some people selected?
All right.
So, if you take care of these issues, I am sure Mr. Sorabjee would be more than happy.
All right, Mr. Sorabjee, do you think that could work, that if the collegiate system is improved upon? That's what the court now says. And these are final words. We just have about 5 minutes left.
No, but that...
Yeah, go ahead, sir.
But that should have been done before striking down the act. Not after striking down the act and putting it later. I don't understand it. That exercise could have been done before the act was struck down or before you gave the judgment on the validity of the act.
All right, Rashwan, you want to come?
I just want to quickly mention Mr. Sambit Patra's question about the fact that what is the role of the judiciary when it comes to when it declares something as unconstitutional. I mean, there was a particular day when the NJAC Act was, Gazette notification happened, and since that time it came into existence. But then clearly, if the court declares that as unconstitutional, it is an automatic effect to it, which is status quo is restored from the beginning. So in some ways, there is an inevitability to the fact that collegium system will indeed come into play, just that the court has actually mentioned very clearly that it will. And I do, one of the things which is important for us to recognize here is that the court looked into very carefully, and I had the chance to read through good part of the judgment, in which the court has really tried to see whether there is possibility for saving certain provisions. And clearly, the court was of the opinion that the way in which some of the provisions were carved, both in the 99th Constitutional Amendment as well as the NJAC, it became simply impossible for it to be saved. And that is why it took to this extreme step of declaring it as unconstitutional.
Sambit, final word to you on this debate.
No, in fact, I think Mr. Chhibber was the one who mentioned that wherever you bring in politicians, they destroy the whole system, to which I would not agree. It is always inclusivity rather than exclusivity which is essential in a democratic setup. And that's why I completely stand with Mr. Soli's statement when he says that the exclusive club of selection is not the right form of selection. It has to be inclusive, in which, well, yes, the court has to, the judiciary has to have the upper hand, definitely, and the system, the NJAC system, provided the upper hand to judiciary. In fact, everyone, apart from the law minister, everyone else was by the judicial selection. So I think, as Soli Sorabjee rightly pointed out, it is not the way you get appointed, it is the way you function which maintains your independence.
All right, Nasir, last word to you.
I think for the Congress party, we'll have to wait how the Supreme Court hearing goes on November 1. But 2, I think what kind of structure statement comes from the government. 3, I think we are not interested into who is making the appointment. We are more interested into seeing how the appointments of these judges are made. Could there be more transparency? Can they be made more accountable, responsible? And that should be in a fashion which could help for in the growth of the democracy, 1. And 2, it should also see that at the same time we also maintain the independence of judiciary, which is a key fundamental to our democracy.
And what options does the government have before it, Maneesh? Final word to you.
There are 3-4 options. They can file a curative. I think they can file a review, which the attorney, I heard him on television saying that is an option which the government is not considering. But, I think the best option for the government would be to engage with the judiciary and ensure that, the case from here on about how to make the collegium system better. I think that is something that is for the government to take it as a challenge and take it to its logical conclusion. In that way, that would satisfy all stakeholders. That is what my view is.
All right, and final word to you, Mr. Soli Sorabjee. As far as this issue progressing from here on is concerned, how do you see it developing?
Well, let's see exactly what the reasoning of the court is for striking it down. I have not read the judgment, I repeat, but I think they thought that under the guise of eminent persons, you may have people not conversant with law and jurisprudence, you may have politicians, and to that extent you may reduce the voice of the judiciary. I don't know whether reading is correct. Even if it is so, then that provision should have been struck down, not the entire act. And mind you, 5 judges and 1 dissenting judgment. So again, there's not very great clarity about it. This matter should have gone to a much larger bench of 9. And it would have been much better if there was unanimity. Because in these matters, people want to know exactly what the position is. The lawyers want to know, the judges want to know. And that, unfortunately, has not been achieved by this judgment.
All right, we'll have to then perhaps wait and watch the...
And if I can just add, even the dissenting judge, he has said that this 5-judge bench could have heard that case.
All right.
He never said that it should go to a larger bench.
On that note, we'll have to wrap it up because we've run out of time. But this is an issue that is of course, critical importance. And we'll be discussing this continuously on Rajya Sabha TV and see how this case progresses. 3rd November is when the Supreme Court would be deciding and would be hearing the government's arguments as to how to further improve the collegiate system. But we'll have to wrap it up over here. Thanks so much for watching. Thank you all of you gentlemen for coming in. Mr. Soli, Sorabjee, thank you very much, especially for coming in. You usually don't do this, but thanks very much for coming in and talking to us over here on Rajya Sabha TV. Well, that's all in the big picture for tonight. Thanks so much for watching. Bye-bye.